Welcome back. As you know, my name is Brian Burkhoff, and this is the New Jersey Workers' Compensation Conversation. Today we'll be talking about how to settle cases outside the industry standard. You may have heard before, petitioner underwent a rotator cuff surgery to the right shoulder, so that case is worth 22.5 to 27.5% of partial total. This is what I mean when I say the standard range that is often discussed. This is important to discuss in the beginning of cases because we do want to use that range when we're setting reserves. There often are most cases settling within that range, but a lot of the time there are factors that make the value much less. So that will be the topic of today's video. How do we point out the factors that can reduce our value much below that range? So, what should we be looking for? First is, I want you to ignore the treatment that occurred. Previously, I mentioned shoulder surgery equals X, and that is the wrong analysis. We are not paying for treatment during permanency. We already provided payment to the authorized provider earlier in the case. What we're looking for now is how did that injury and treatment impact petitioner's shoulder and how they're going to operate for the rest of their life. We pay permanency by looking at the Perez factors and Section 36. Has it impacted their ability to work? And has it had a substantial impact on their activities of daily living? So, once we have obtained our permanency reports and are trying to determine the value of a case, I begin by closely reviewing what both doctors have to say. Our doctors frequently give a great history of petitioners' abilities before the accident and their current abilities. They'll say whether there's anything that they can no longer do that they did previously. This will be with respect to work and their daily life. We can use those indicators to say whether or not petitioner truly has a permanent disability to the alleged body part. However, most of the times you'll see in our reports the doctors are told, I'm fine. I'm back to working the same job, and I'm doing everything around the house that I was able to before this work accident. It's in these types of cases that we want to push for much lower settlements. Similarly, if you look to the petitioner's expert report, they often do not have any information about the restrictions petitioner is currently facing. They'll discuss pain that's stabbing and shooting and aggravated by weather, but they won't say petitioner previously was able to golf, bowl, and do a bunch of other things which they cannot currently do. Sometimes they will, and we'll have to factor that into the analysis, but there's many petitioners, permanency experts that fail to include a full analysis of this discussion. So, once we review the permanency reports, where do we go from there? Let's use the example we've been discussing of an individual with a shoulder surgery. But let's assume that the permanency reports say that they have no issues at home, that they're able to do all their normal household chores, and that they've returned to work full duty. Regardless of this, we're going to get a demand from petitioner's attorney, let's say of 30% of partial total since there was a surgery to the shoulder. I'm going to review the permanency reports closely, and I'm going to respond by saying that case is not worth close to that. If we were to go to trial, the petitioner would not be able to prove that they have a permanent injury to their shoulder. Sometimes I will then recommend to the client to get updated surveillance or surveillance to begin with after we've had our permanency evaluation. If it seems like that the petitioner is being, let's call it, untruthful about what they're able to do, so we know that they're back to work full duty and they're lifting 50-pound jugs 100 times a day, but they tell our permanency expert that they can't vacuum or mow their lawn or do other things that doesn't correlate. We'll often recommend getting updated surveillance, and if we catch petitioner doing that, it obviously would be a really positive outcome in our case. But in this situation that I've discussed where we're having an offer of 30% of partial total, yet there's nothing that would actually correlate to that award based on Perez and Section 36, I would start with a much lower settlement offer or recommend that to the client. Say somewhere around 12.5% of partial total. Now, when I make that offer, the petitioner's attorney is going to laugh He's going to say there's absolutely no way that this case is worth less than the mid-20s, and he's going to request a conference with the judge. And the judge most likely is going to agree with the petitioner's attorney. He'll say, Brian, I have cases all the time. Shoulder surgeries are worth blank. And I'm going to say, Judge, I don't care what the treatment is. The best way to get positive results outside of standard norm is to stand firm, because the judge knows we have the money. The judge is going to ask that we provide a fair settlement based on all the other cases that they see, so that they can move the case off their docket and get to the next one. We have to be willing to say, no, we're not willing to pay that standard range in cases where the value isn't there, when there truly isn't a permanent disability. And in those cases, we have to say, let's move the trial. Let's force the petitioner to sit on the stand and admit to everything they can or cannot do. So, in this scenario, we might be having to head to trial. But if petitioner is forced to sit on the stand and actually fully describe the impact of this work accident, we'll have a much better picture of what the value is going forward. Now, you may be thinking, this sounds great in theory, but in practice, it's going to be too difficult to get the results. Because, as we mentioned, the judges are trying to move their cases, and also it's workers' compensation, not employers' compensation. So there's a lot that goes against us. But let me tell you about a few examples in real life where I was able to get an award that was much less than what would be considered the industry standard. Earlier this year, I had a case where the petitioner underwent a total hip replacement. In cases like these, the petitioner's attorneys automatically assume they had X treatment, so they should get an award absolutely over the hump, and most of the time close to 50% of partial total. However, in this instance, we had a really great report from our permanency expert. He went into great detail to explain how the petitioner was able to do all the things that she was before the accident, including vacationing regularly, going to the Jersey Shore, walking up and down the beach. She was back to the same job, working full duty. And overall, it appeared she was in much better shape now than she was before the surgery. So, unsurprisingly, we got a settlement demand of 50% of partial total, to which I responded with an offer of 22.5%. This cut the value of the case in less than half. Petitioner's attorney immediately scoffed at the idea, requested a conference with the judge. Even with discussing with the judge, there was a recommendation over the hump, and I said that we could not agree to it and that we wanted to proceed to trial. In the 11th hour, the petitioner's attorney came back and said that they would settle the case for 25% of partial total, which we agreed we would do. Compared to the original demand, this was a saving of over $165,000 to our client. And this is what happens when you're standing firm and willing to take the case to trial. The petitioner's attorney was laughing, the judge thought it was over the hump, but you have to stand firm on Perez and Section 36. If there is no impact to petitioner's life or activities of work, they are not entitled to an award of hundreds of thousands of dollars. Another example is from a few years ago when petitioner underwent a multi-level fusion surgery. There were some causation issues due to the accident and the existence of prior issues. However, multi-level fusion surgeries, when authorized by the respondent, regularly go for well over the hump and sometimes are in the range of 40% of partial total. In this particular case, we got a demand in that vicinity. However, again, our permanency expert provided a great report that noted the petitioner was swimming multiple miles a day, going for long runs, and working out at a gym regularly. She was working at the same job, and overall there did not appear to be any change in her life compared to when this work accident occurred. Overall, she was in better shape than I was, and yet was making a demand for hundreds of thousands of dollars based on her, quote, disability. In this situation, we pushed hard back against the fact that they wanted an order approving settlement, and we ended up settling the case for a Section 20 that closed it out permanently. Now, granted, since there was an authorized multi-level fusion, this was a significant settlement award of around $75,000. However, petitioner was in her 30s, so we are now off the hook for all future treatment and do not have to worry about them coming back for additional permanency benefits either. A lot of times, petitioners who undergo multi-level fusion surgeries can end up totally disabled, and the cases become worth hundreds of thousands, if not over $1 million. So, based on these two examples, I truly want to emphasize the importance of standing firm, be willing to go to trial, know the Perez factors and the definition of permanency under Section 36, and also make sure you have great permanency experts, because both of these instances, our experts' report was what allowed us to settle the case favorably. If we had a really poor report, we would not be in the situation that we are now. So, if you have any questions about this topic or have cases you're currently dealing with that sound like they should go for below the industry standard, feel free to reach out to me. I'm happy to discuss your issue in person or on an upcoming video. You can email me or give me a call as well. So with that, I hope you have enjoyed our compensation conversation, and I look forward to talking again soon.